Good morning. Good morning, my name is Wendy. I'm a professor from Ghent University, and I'm very happy to be able to welcome you to our session on equal treatment within the EU. You can see that there's three of us up here, so I will do a short introduction, and then Annika on the left-hand side, she's our Swedish colleague, or for you on the left, she's our Swedish colleague, who will dive into the case study of Sweden, and Nele will do a case study for Belgium. I will do a short introduction to their presentation so that you know a little bit what we mean or what the problem is, our focus when it comes to equal treatment or unequal treatment in the European Union. So I'll give an introduction. I tried to make it a little bit visual, my slides, to facilitate or to make it sure that you could more easily understand. This is a picture of Muriel, the lady on the screen. Muriel is a young lady. I decided not to take a male offender, but I taken a female offender. Muriel is a young lady. She's very active. She travels about in the European Union. She actively uses the right to free movement. And as you can see from this picture, Muriel lives in the north of Spain, but she actually has the ambition to move about a little bit. She wants to move to the north of Poland. As you can also see from this scheme, Muriel has a criminal record, or at least that's what the other button does. She has a criminal record, and if she moves through the European Union, that criminal record will move together with her. So if she moves, the criminal record and the effect thereof will move together with her. Now, within the European Union, we have a fairly well-elaborate system of cross-border effect on criminal convictions and cross-border effect thereof. So Muriel will be able to benefit from what we call the neighbors in Eden principle. So she will not be able to be prosecuted again for the offences she's already been convicted for. She can benefit from the cross-border execution of sentences. So if she resides in another country than the country that has handed down the execution or the conviction, she can have it executed in another country. So if you go on holiday and you're convicted there, it makes sense that you come back home and have the execution of your sentence in your home country. And she'll also be able to benefit, I'm not sure if it's benefit, from the taking account of prior convictions if she commits a new offense. So if she commits a new offense, that prior record that she has, regardless of the origin, will be brought up in court again. So we have a fairly good system of people being able to move around and have the effect of their convictions move around as well. There's only one big gap in the EU legislation, and that's our focus of today. That is the impact of this cross-border movement when it comes to multi-offenders. And that's the focus of the case studies that Annika and Nele will conduct. And now we'll give you a little bit of an introduction as to what multi-offenders are and what European rules would come to mind. So I'll first do multi-offenders, and then I will point to a gap in the EU legislation which opens the door for some strange or inconsistent national legislation that might give way for unequal treatment or disproportionate sentencing. So let me first reiterate for your convenience what a multi-offender is. So as the concept suggests, it's a person who's committed multiple offenses. So I will turn Muriel into a multi-offender, and as you can see from this picture, she's committed 3 offenses over a specific course in time. It's important for you to note that she's not been convicted before. She's committed offenses continuously, and then at a certain point in time, those offenses or that case file will be brought in front of a judge. And when sentencing or when trying to sentence Muriel, that judge will start calculating to see what sentence would be appropriate for the offenses she's committed. And what's interesting is that it's very unlikely for her to receive a sentence that's merely the sum of the individual sentences that applies. Usually that's not what's done. There's some sort of what Nele always calls a bulk discount. You get a discount if there's a bulk of offenses being brought in front of a judge. So this is what we call multi-offenders, and this is going to be the focus of the presentations of my 2 colleagues. Now it becomes more interesting, of course, if this is not what happens, but if the offenses of Muriel are not discovered all at once. So let's say that there's a sort of seizure, césure, so that only 2 offenses are maybe discovered, 2 offenses are brought to the judge, so that first conviction that she has only relates to the 2 first offenses, and then later on the prosecution discovers more offenses, or it becomes clear that Muriel was actually the author of the offenses. So later on, after she's been convicted for those 2 first bullets, she will, or the question arises whether she can be prosecuted and sentenced again for that 3rd offense that she also also committed. So the question is, what will happen if that in a third or in a second go that 3rd offense would be brought in front of a judge? Is there going to be a second conviction or not? That's a very interesting question, and the answer to it is as simple as it is complex. The answer to it is, it depends. It depends on the link between the offences she has committed, or in most jurisdictions, it depends on the interaction or the connection between those offences. Are they completely disconnected, random offences, or is there some sort of link between them? And to make that a bit more tangible, I will give you an example. So let's say that she's committed 3 offenses. I've taken a hit and run on a drunken night out, the second one being a tax offense, and then the 3rd one, a little bit inspired by this occasion, the 3rd one is that she calls in a false bomb alert. Those 3 offenses are completely disconnected. And if she's convicted for the first 2, there seems to be no reason why there should be another prosecution and another conviction for the 3rd false bomb alert that she has called in. So if those offenses are completely disconnected, there's not going to be that much of a problem in most jurisdictions to have a second prosecution and a second conviction for that same person. It becomes more complex when there is sort of a link between the offenses she's committed. So I've given 2 examples here on the slide. Let's say that she has a lucrative business in selling airbags of very expensive cars, luxury cars, and she's committed several airbag thefts. I've put 3 here on the slide, but there could be more. It's a very lucrative business that she's running. What if she was convicted for a number of airbag thefts and her business was exposed, and we know that that's her activity, but then ultimately in the end there's one more airbag theft that is being discovered? Can she then again be convicted for the business she was already convicted for or not? Some will say, obviously not. This is a case of ne bis in idem. She was already convicted for it. It would be disproportionate to convict her again. Obviously, she's going to have committed more. Whereas others will say, no, because ne bis in idem only applies to the exact same acts. And a 3rd or a 4th or a 10th theft is a new act. And so it wouldn't be idem. Of course, you can prosecute her again, but it has to be slightly proportionate, the sentencing, so you have to take account of what is already being done in the past. That proportionality argument is also what is being used when there is a sort of link between the offenses because they are part of the same plan, one criminal plan that is being thought out by Muriel. So let's say she first acquires an illegal weapon, then she steals a vehicle, all with the view of committing an armed robbery on a bank. There too, some argue that the interlink between them should make sure that the case is tried a little bit together, or that the interaction is taken into account when sentencing. So sentencing a multi-offender, especially if it's split over several procedures, is not that easy. If they're completely disconnected, then it's fairly straightforward. If there's some sort of a link, then the legislation and rules in the different member states vary quite significantly. The arguments that are being used are ne bis in idem, although not everyone agrees on what it exactly entails or on which cases it should apply. And the other argument that's being used is proportionality. Although there too, there is no common understanding as to what would be proportionate or disproportionate. in between the member states. So as those national rules vary so much, and as we know that we have people moving across the border and we have cross-border prosecutions and sentences, we might expect, or I think it's fair to expect from the European Union or the European legislator more in general, to give a little bit of guidance, to have some rules or guidance to make sure that if those multi-offenders are confronted with a cross-border element, their bulk discount doesn't disappear, or at least they don't suffer any negative consequences from the fact that there are more member states involved, because that's the ultimate underlying philosophy or concept of European cooperation, that people don't have negative consequences of cooperation between member states. So in my opinion, or in my view, it's fair to have three expectations from the European Union. I think it's fair to expect that the EU has some position on what EDM should mean, whether EDM applies to multi-offenders or not, and under which circumstances or in which cases. I think it's fair to expect from the European Union to have some rules or guidance when multiple member states are simultaneously trying to prosecute parts of that multi-offense. What needs to be done then. And thirdly, I think it's also fair to expect the European Union to have some guidance or rules when, in a successive way, there are consecutive procedures in multiple member states all relating to a part of that multi-offense. Now, if you look at the actual European legislation and policy, I can tell you that the outcome of it is very disappointed. We have no consistent rules or no mandatory rules relating to any of this. And in the next few slides, I will show you what the gap is in the legislation of the European Union and which doors are opened for national member states to have some quirky regulations in this respect. So first of all, I said that the first expectation that we can have from the European Union is to shed some light on this concept of EDM. Is multi-offending EDM, yes or no, and under which circumstances? And if you look into the three pieces of legislation that are important or that relate to this topic, you will see on the left-hand side KISA, which is the Schengen Implementation Agreement. In the middle, you have the European Charter on Fundamental Rights, and on the right-hand side, you have the European Convention on Human Rights, which is the Council of Europe instrument. Now, if you look into those instruments to see what does the European legal framework tell us about EDM, you will see that, interestingly, there's one that refers to same acts, but we're still not sure whether that is in a physical nature or is some similar acts, whereas the other two are a bit more restrictive and refer to offense. This is not very informative if you want to know whether it applies to multi-offenders. Or Muriel, when she's committed multiple airbag thefts, has she committed the same act? Or is it the same offense because it's like stealing multiple things to run a business? Now, luckily, the case law of both European courts is a bit more informative, although not that, in the sense that it says that it's sufficient for the offences or the behavior to be the same or of similar nature, and that there is a link in space and time. Now, it's still a little bit vague, but it clarifies that it shouldn't be read as restrictively as we might think when we come to have a look at these provisions. Now, the second thing is, if we've established that in some situations, multi-offenders may benefit from ne bis in idem, we still need to know what it is they benefit from. So what is it that you cannot do twice? Is it prosecution? Is it sentencing? Is it executing a sentence? And here too, you can see that there's quite some difference in these instruments, whereas some say prosecution, others say try and prosecuted. So there's no consistency in that regard as well. So this is the first gap. There's no European rules on what qualifies as EDM. So if we want to know whether multi-offenders would qualify as EDM or be able to benefit from EDM, we're really left in the dark in that respect. the second and third expectation that we can have from the European Union has to do with cross-border elements being added to it, and that's the reason why I've put these two schemes on the slide. So if we were to say that it was EDM, or if we weren't to say that it is EDM but just proportionality, we still need to know what to do when multiple member states are working on that same case file. So let's take the airbag business as an example. Let's say that one case or one act, one theft was carried out in Belgium and it's prosecuted in Belgium, but at the same time the French have introduced or started a prosecution for 2 cases of airbag theft in France. So they're simultaneously working on the same case that if it was supposed to, or if it were to be convicted, conducted in one country, it would qualify as a multi-offender case. So what would happen then? Do they both prosecute? Is the prosecution going to be concentrated in one member state? Is it just everybody doing as they see fit? So that's the first problem that Muriel may experience, simultaneous prosecutions for, in her opinion or in her mind, the same criminal activity that she conducts. And the second possibility is that if those 2 French offenses of the behavior that she's committed in France is being convicted in France, and then later on in Belgium we discover that she also committed an airbag theft in Belgium, and we prosecute, or we want to prosecute her for those offenses as well, which is consecutive prosecutions for a multi-offense. Now, I hope you're still with me. If we look into these simultaneous prosecutions and we look into the instrument that relates to it, we can see that it is not very, or it is slightly disappointing for Muriel. So it says that if 2 countries are trying to prosecute on the same case, there should be consultation. And you should try to come to a sort of consensus on where to concentrate the case. So that's the ultimate goal, or that would be the best option. But if you can't reach a consensus, don't worry. All of you can just continue your proceedings just like that. So it means that the bulk discount or the benefits or the disproportionality arguments that we have just completely fade when there's 2 countries involved, because all of you can just prosecute the case and just ignore the fact that there's another case in another country ongoing. The same is true, or the same disappointment you can feel when there's consecutive proceedings. We have a framework decision that introduces as a general principle that we respect and recognize each other's convictions. So if a person is convicted in one country and then comes to your country, you would treat that foreign conviction just as if it was your own, and you would take it into account when you calculate your sentences. That's what the framework decision does as a general principle. However, interestingly, it says when it comes to multi-offenses, the first part of this article clarifies that it relates to that. It says you have to take account of prior convictions generally, except for those situations. So the requirement shall not have the effect that a judge is supposed to, or judge can be limited in imposing a sentence. So if you would be limited in imposing a sentence because it's part of something that was already convicted, then you can just ignore the foreign conviction and just do as you see fit. So here too, it is clear that the European rules just ignore the entire discussion that we have when it comes to sentencing multi-offenses, and Muriel can just be sentenced over and over again, resulting in a potentially disproportionate and unbalanced sentence. So these are important EU gaps when it comes to multi-offending. So there's no common understanding on when it is relevant, when different offences would qualify as EDM or as a sort of group of offences that need to be taken into account when sentencing. There's no rules on concentration of, or no mandatory rules on concentrating cases, even though in a national jurisdiction you would. And there's also no rules on taking account of prior convictions in these specific situations. So taking this as a starting point, it is clear that the European Union leaves the door wide open for national member states to just decide on rules and to make a distinction between multi-offenders in a mere national context and multi-offenders with a cross-border element of some sort. So it leaves the door wide open to unequal treatment between people that have and don't have a cross-border element, and disproportionate sentencing if in a mere national case they would feel it disproportionate to just add up the sentences, but if it's a cross-border case you can just have various convictions next to each other. So based on this finding the gaps in the European legislation, both Nele and Annika have looked into their national laws to see to what extent there are rules and there are clarifications on what to do with multi-offenders, and whether in their national jurisdiction there is a distinction made between multi-offenders that have a mere national case file, let's say, and multi-offenders that have a cross-border element to it. So I will first invite Nele up here. Nele is one of my PhD students, so she's doing a research into specifically this treating of multi-offenders and how it should best go about. And she will look into the case file of Belgium, and then afterwards I will give the floor to Annika, and then in the end we can have some questions and we can maybe have a discussion on what your views are on how we should go about with multi-offenders. Are we just simply to ignore it and add up all the sentences or not? Should there be a relevance of this cross-border element or not? I think or at least me, but I think also both my colleagues would be very interested into hearing what your views are on how to go about with multi-offenders. So first, hand the floor to Nele. You can come up here, and then afterwards we'll hear Annika. There you go.
Thank you for the introduction, Wendy. Good morning, everyone. My name is Nele Audenaert, and I'm a second-year PhD researcher at Ghent University. What I would like to discuss with you today are the legal effects that the Belgian legislator attaches to previous national and previous foreign convictions when sentencing repeat offenders on the one hand and when sentencing multi-offenders on the other hand. What you will soon find out is that despite the existence of the framework decision on taking account of foreign convictions, the penalties that can be imposed on repeat and multi-offenders can considerably differ according to the question which member state handed down the previous conviction. And to conclude my presentation, I will bring up some discussion points in this regard. First of all, let me take a start by shortly telling you something about the consequences that can be attached to previous conviction in Belgium. First of all, the previous national convictions. As you can see, the possible consequences of previous national convictions are numerous. When an offender has a criminal record, this criminal record can importantly affect some decisions on the prosecuting level, on the sentencing level, and on the executing level in a criminal procedure. Since Wendy already told you something about problems concerning the nebis in idem principle, and since today for me especially the sentencing level is relevant, I will not go further into detail onto the prosecuting and executing stages. I will do that on the sentencing level. When sentencing, especially repeat offenders and multi-offenders are experiencing some negative consequences in case of repeat offenders, or some positive consequences in case of multi-offenders due to the existence of a previous foreign conviction. I will come back to you later on the difference between both types of offenders, but what I can already tell you is that firstly, repeat offenders are being punished much more severely than multi-offenders, even if they have committed the exact same offenses in almost the exact same circumstances. And secondly, that there is an important difference between the punishment of repeat offenders in a transnational context and the punishment of multi-offenders in a transnational context. So this for the consequences, the possible consequences of previous national convictions. What about foreign judgments? Do they have the same consequences as national judgments? they should have. Wendy already explained to you the framework decision of 2008 on taking account of foreign convictions. This framework decision actually aimed to establish a kind of principle of assimilation, a principle of equivalence between foreign and national judgments. So theoretically, each member state is obliged to attach to foreign judgments the same legal effects as they attach to previous national judgments. And the development of such a framework decision was very welcome, because we can see before 2014, before the implementation of this framework decision in Belgium, we did not recognize the existence of previous foreign convictions. We simply ignored them. So only previous national convictions could sort any effects in the Belgian legal order. It was only after the implementation of the framework decision and after the implementation of the equivalence principle that now foreign judgments are treated in the exact same manner as national judgments. But unfortunately, I immediately have to point out that we did not only implement the equivalence principle, but also the optional ground for non-equivalence included in the 5th paragraph of Article 3 of the framework decision. And according to this article, we can still choose to ignore a previous foreign conviction when this would limit the judge in imposing a sentence. In human language, when a judge would not be able to impose the sentence, the penalty, he would like to impose without the existence of the previous foreign conviction, we can ignore it. And this exception actually renders the equivalence principle rather ineffective, because in some cases, equivalence between foreign and national judgments is still nothing more than an illusion. And especially multi-offenders, as we will see later, seem to suffer from this exception, because repeat offenders in a national and in a transnational context are being punished in the exact same manner. So then we apply the equivalence principle, but multi-offenders in a transnational context, so with a cross-border element, will be punished much more severely than multi-offenders in a mere national context. And I'm not sure whether this difference in approach can be justified. So that is what we are going to take a look at today. And I will start by telling you something more about how repeat offenders and multi-offenders are being punished in Belgium. First of all, repeat offenders. What are repeat offenders? Repeat offenders are offenders who are being prosecuted for an offense that they committed after already being finally convicted, and final is very important, after being already finally convicted for another offense. So repeat offenders are offenders who commit an offense whilst already having a criminal record. And what you can clearly see from the slide is that it is very important that the second offense was committed after the conviction for the first offense has become final. Because if the second offense, for example, was committed after the conviction had been handed down, but before this conviction had become final, then we will not apply the rules for repeat offenders, but those for multi-offenders. And as I already explained to you, the difference can be very relevant. A lot of approaches exist concerning the question how repeat offenders should be punished. I will shortly discuss 3 of them, merely to show you that it is very contested how you should punish a repeat offender. First of all, the first approach has been laid down by the first offender school. The first offender school, they think that we should reward a discount, that we should grant a discount to first offenders, that we should reward them for not having committed an offense before. They are like, wow, congratulations, it's your first offense. You have never committed an offense before. Wow, we think that deserves a discount, that deserves a reward. So first offenders, according to this school, must be punished more leniently than legally foreseen for the committed offense. The recidivist premium school doesn't agree with this point of view. They are like, why should we grant a reward, grant a discount to people that have never committed an offense before? I mean, isn't it normal that you do not commit offenses? A lot of people do not commit offenses, so why we should give first offenders a discount? That doesn't make any sense. No, they think that repeat offenders, so those who commit more than one offense in their lives, they should be punished much more severely than legally foreseen for the committed offense. The third approach, the third school, the exclusionary school, adopted a more neutral approach. They think that the penalty that can be imposed can only be affected by the offense itself, by the seriousness of the committed offense, and that the criminal record should not affect this penalty. So the non-existence of a criminal record cannot justify a more lenient penalty, and the existence of a criminal record cannot justify a more severe penalty. So they think it doesn't matter how many offenses you have committed in your whole life, we only take a look at the offense that you have committed and that have been brought to judge at the moment. Without bothering you with the details, I can tell you that the Belgian legislator followed the recidivist premium school. So in Belgium, repeat offenders will be punished more severely than legally foreseen for the committed offense. Of course, this depends on several criteria, such as the seriousness of the previously committed offenses, the seriousness of the newly committed offenses, the amount of time that has passed between both of them. But in general, we can say that most of the times, recidivists, having a criminal record can aggravate the sentence and will lead to a more severe penalty. This also means that a first offense will cost you more than a second, third, a fourth offense. And that if, for example, a repeat offender has committed 2 car thefts, the first car theft will be punished less severe than the second car theft. So the second car theft will actually cost you more. For example, if car thefts are normally punishable with an imprisonment sentence of 3 years, the repeat offender will receive a penalty of 3 years imprisonment for the first car theft, but might be imposed a penalty of 5 years imprisonment for the second car theft. And this severe approach is said, although universally contested, is said to be based upon the proportionality principle. Proportionality principle states that you should punish an offense according and proportionate to its seriousness. And they think that having a criminal record increases the seriousness of each offense you commit afterwards, after that first offense. So that is the reason why we punish repeat offenders more severely. But this is only a national context. So what happens when the previous conviction has not been handed down by Belgium, by a Belgian judge, but what happens when the previous conviction has been handed down by another EU member state? Before 2014, nothing happened. We did not take into consideration the existence of a previous foreign conviction because we didn't implement the framework decision of 2008 yet. So only national convictions could aggravate the sentence. A previous foreign conviction, a foreign criminal record, did not have that same consequences. But luckily, after 2014, things changed. And now, indeed, we do treat foreign judgments in the same manner as national judgments. So a previous foreign conviction will have the exact same effect in a following criminal procedure than a previous national conviction. So the penalty will be equally severe regardless of the question where the previous conviction has been handed down. Situation is somewhat different for multi-offenders. What are multi-offenders? The multi-offenders are also offenders who have committed more than one offense in their lives. But as opposed to repeat offenders, they committed all their offenses before being finally convicted for one of them. And as Wendy already briefly discussed with you, 2 situations fall within the scope of the sentencing rules for multi-offenders. The first situation is the most simple one. It means that, for example, an offender has been able to commit 4 offenses before being prosecuted for all of them at the same time. So in this situation, all the offenses are being tried in the same criminal procedure. The second situation is a bit more difficult. And in this case, the several different offenses are not being prosecuted at the same time. But a few of them might be prosecuted in a first criminal procedure. Other offenses might be prosecuted in another criminal procedure. So in this case, several different offenses are being tried in several different criminal proceedings. Now, the most important question, how are they being punished? And does it make a difference whether all the offenses are being punished at the same time or not? Again, first of all, what happens when the previous conviction, in this case, so in the latter situation where there is a previous conviction, is a national one. I will first tell you something more about the first situation, because this is the most simple to explain, and this explains why we do what we do in the latter situation. So how are multi-offenders being punished? In general, I can tell you that multi-offenders are being punished more leniently compared to offenders who only commit one offense, in the sense that they will actually, that the penalties for the different offenses that they committed will never simply be added up. The penalty will actually always, almost always, be more lenient than the sum of the different penalties foreseen for the different offenses. And why is this? This is based, again, upon proportionality reasons, because we think that if we simply add up the different penalties foreseen for each offense, that this will result in a disproportionate penalty, in a disproportionate sentence. For example, if someone has committed 100 car thefts, he might be punished, in theory, with an imprisonment sentence of 300 years. We think that is not proportionate for 100 car thefts. So that is why we do not simply add up the different penalties. We are also worried about the risk that a multi-offender will be punished as severe or even much more severe than an offender who actually committed a much more serious offense. For example, in this case, our multi-offender committed 4 offenses, and he can, if we would simply add up all the penalties, he could be punished with an imprisonment sentence of 14 years, whereas a murderer could only be punished with an imprisonment sentence of 9 years. And we think this is disproportionate, because we think murder is really the worst of all offenses, and it shouldn't be that someone else, drunk driving, who doesn't do that, we don't think that they should be punished more severe than someone who commits a murder. And that is why we got the sentence. And a judge who is being asked to rule upon multiple offenses can actually never impose a penalty that exceeds the maximum penalty that is foreseen for the most serious offense. In this case, the bank robbery is the most serious offense, since it can be punished with an imprisonment sentence of 6 years. So the judge can only impose a penalty of maximum 6 years. We think this is proportionate because, in this case, our murderer is punished much more severe than our multi-offender. And since it is also considered disproportionate to punish someone more severe when the number of criminal proceedings increase, this maximum penalty also applies when the different multiple offenses are being tried in several different criminal proceedings. So, for example, if a judge is being asked to rule upon 3 of the 4 offenses committed by the multiple offender, then he has to apply the basic rules, and he will say, okay, maximum sentence of 6 years, because that's the maximum penalty foreseen for the most serious offense. If afterwards it is being discovered that the multiple offender also committed a car theft, and this car theft is being brought before the judge in the second criminal procedure has actually no other possibility than merely finding him guilty. He cannot impose an additional penalty, because we say it would be disproportionate that both penalties, that the total of the penalties that are being imposed for all the multiple offenses together would exceed the maximum penalty foreseen for the most serious offense. So the sum of these 2 penalties can never exceed our maximum, because otherwise, again, he would be punished more or as severe as a murderer. But there are also other possibilities. For example, in this slide, you can see that the judge in the first criminal procedure did not consider it necessary to punish the offender with an imprisonment sentence of 6 years and only imposed an imprisonment sentence of 5 years. The judge in the second criminal procedure can then impose an additional penalty of 1 year, because the 2 penalties added up together will never exceed the maximum penalty foreseen for the most serious offense of all offenses together. And 2 things are very important on this slide. First of all, we can see that as opposed to repeat offenders, in this case, a second, a third, a fourth offense will cost you less than a first offense. Because, for example, if the multi-offender originally only committed a bank robbery and afterwards was being caught for car theft or drunk driving, the other offenses are actually being committed for free because they can never lead to an additional penalty. The bank robbery itself already led to a penalty of 6 years, and all the other offenses are committed for free. The second thing you should remember from this slide is that it is clear that in this case, the judge in the second criminal procedure is being limited in imposing a penalty. Because normally a car theft would be punishable with an imprisonment sentence of 3 years, but in this case, he can only impose a penalty of 1 year imprisonment. And in the previous case, he wasn't even able to impose an additional penalty. So, for national convictions, what about foreign convictions? Again, can we assume that foreign convictions have the same legal effects as previous national convictions? And that in this case, it wouldn't matter that this first criminal procedure was being conducted in another member state? We'll see. Before 2014, again, we didn't take account of previous foreign convictions. It didn't matter. We simply ignored this procedure. So for the car theft, punishable with an imprisonment sentence of 3 years, the judge could impose this additional penalty. He didn't take account of the penalty imposed in this first procedure, in this first foreign procedure. And we can see that, again, this leads to what is, according to the Belgian legislator, a disproportionate penalty, because, again, both penalties together will be as severe as a penalty that can be imposed on a murderer. But we would expect that after 2014, after the implementation of the framework decision, things changed. Because the proportionality principle, it has been recognized at a European level. We should also apply it when the previous foreign conviction was been handed down by another member state. We have the equivalence principle. We should go back to this situation. Let's see. Of course, nothing could be further from the truth. In this case, we do the same as before 2014. We simply ignore the existence and the penalty imposed in that previous foreign conviction. Why is that? I already told you that we did not only implement the equivalence principle, but also the exception on the equivalence principle. And this exception allowed member states to ignore previous foreign convictions when this would limit the judge in imposing a sentence. And indeed, you can see that in this case, he would not be able to impose an additional penalty if we would have to take account of this previous foreign conviction. And that is the reason why we ignore it and why we simply allow the judge to act as if the car theft did not belong to a series of multiple offenses. And this leads to a somewhat, according to me, remarkable conclusion. Because we see, when we compare the situation of repeat offenders with the situations of multi-offenders, we actually see that that mutual recognition, that the equivalence principle only is being applied when this would harm the defendant, when this would be in his disadvantage, when this would lead to a more severe penalty. We can actually never benefit from the equivalence principle, because, yeah, if you cannot impose a penalty you would otherwise impose, then you can choose to ignore the previous foreign conviction. So actually, it is only being, the equivalence principle is only being applied in disadvantage of a defendant. And yeah, it's remarkable because Recital 8 of the framework decision of 2008 states that the equivalence principle is a neutral principle. And it is obvious that this non-neutral application in reality gives rise to some discussions in this regard. Is it really a neutral principle? I'm not sure. But besides these ethical concerns, also some legal concerns can be expressed. As I told you, the punishment, the punishing rules, the sentencing rules for multi-offenders are being based upon the proportionality principle. Proportionality principle has also been recognized explicitly at the European level in the EU Charter. Severity of penalties must not be disproportionate to the criminal offense. Although it is not clear to what extent the proportionality principle actually requires us to punish multi-offenders more leniently, I think that if you state that it does require it, that you should not only apply this in a national context, but also in a transnational context, especially since the proportionality principle has also been recognized at a European level. So I'm not sure, it might be that the current situation within Belgium, the current different treatment of multi-offenders according to the nationality of a previous conviction, might violate the European proportionality principle. The same applies for the equality principle. According to the equality principle, like cases should be treated alike, different cases should be treated differently. And in this case, multi-offenders who have committed the exact same offenses in the exact same circumstances might be treated and punished differently according to the question which member state handed down the previous conviction. If the previous conviction had been handed down by Belgium, we punish them more leniently than when the previous conviction has been handed down by another member state. And the question arises, so the only difference between the two situations are actually the number of prosecuting member states. So are all the convictions been handed down by the same member state or not? Or the nationality of the previous conviction. As in the previous conviction, is the previous conviction a Belgian conviction or is it a foreign conviction? I'm not sure whether these two criteria can justify a different treatment. So it is also not very clear whether the current situation in Belgium violates, to what extent it can violate the equality principle. And then, of course, since we have a possible violation of proportionality principle, a possible violation of the equality principle, I'm asking myself the question how this can be justified, because in Belgium, the Belgian legislator only raised some practical concerns and some ethical, moral concerns, which were, according to me, either not convincing or either not acceptable any longer in a European area that is based upon mutual trust. So I'm wondering, how can this be justified, this different treatment of multi-offenders according to the question where their previous conviction has been handed down? Because that is really the only difference between the treatment of multi-offenders in one context and treatment of multi-offenders in another context. And what you should remember from this presentation, the most important thing is that the different punishment of multi-offenders in a national and in a transnational context not only feels illogical or strange, especially compared to the assimilation between repeat offenders in a national and repeat offenders in a transnational context, but also gives rise to a lot of questions, for example, concerning the proportionality and equality principle. Thank you very much for your attention.
Good morning for me as well. My name is Annika Suominen. I'm either you can call me a senior lecturer or assistant professor in criminal law at the Stockholm University. I tend to speak too fast, so please inform me if this is way too fast for you. I should also maybe make as a declarator or information say that I'm not a Swedish lawyer and I haven't worked for that long in Sweden yet, just so you know. I have some general introduction, which I think I will not go through because you've already heard it, and I think you presented it very well both, so I will just basically go straight on to my presentation. Today I will then discuss or address the Swedish policy for sentencing cross-border offenders convicted before in another member state. I've decided that I will start with first discussing very briefly the framework decision and its non-implementation into the Swedish legal order. Then I will because it's not implemented, then I will explain the Swedish system of sentencing in a fairly brief way, otherwise we would be here for a long time. After that I will address some relevant issues which come up to light, also in relation to the presentations we've heard before, and then I will also try to conclude some smart thoughts that we can work further on. I can also already now make a clarification stating that I will only in this presentation talk about prior convictions in relation to sentencing the defendant. So I will, as Nele, leave out the nebis in idem issue as well as for execution of sentences because that would be too big. As I already mentioned in my introduction, the framework decision does obligate Sweden and, of course, all the member states to unconditionally, in some situations, take into consideration previous foreign conviction and to treat cross-border offenders similarly as purely national offenders. What then makes this, I would say, very interesting for Sweden is that the Swedish legislator considered that this does not need any form of implementation into the Swedish system. They simply stated that it is not necessary to amend the current legislation, and applying the relevant rules of the penal code can continue as before. The framework decision stated that cross-border convictions should have the same effect as national ones. What was also, I think, quite interesting when the Swedish legislature said that they also pointed out that as the framework decision is also fairly restricted, and pointed especially out to Articles 3.3 to 3.5, which we have also discussed before, therefore there was simply no need to amend the rules, especially in Chapter 34 of the Swedish Penal Code. I will discuss them later in a second. And they simply also stated that the existing legal framework, the travaux préparatoire and the case law were also not any form of hinder in then applying the relevant Swedish provisions also to convictions given in other member states. Therefore, if you look, you will not find any form of implementing legislation, and the legal position with the relevant or the relevant applicable rules in the Swedish Penal Code apply, let's say, normally. And when you then look at, for example, how Sweden reported to the Commission in relation to the implementation of the framework decision, and then were stating how this applies or which are the relevant legal provisions, this is what they told the Commission. Obviously, I'm not going to read through all of this, and it's not that important to note, then I would just simply say that the list is quite long, and of course, if you say, like the Swedish legislator has chosen to say, that you can always read when it says conviction, you can also consider a foreign conviction falling under that definition, then of course the number of legislation and sections that are relevant is quite large, I would say. I would, however, as a starting point, also say that regardless of the non-implementation of the framework decision and the fact that like the amount of possibilities where this can actually affect the applicability of Swedish law, I don't think that I wouldn't necessarily argue that this automatically means that there is a lack of sentencing policy concerning cross-borders, repeat and multiple offenders in Sweden. Because the approach taken by the Swedish legislature is that the national rules apply in the same way, regardless then of the previous offense or where the previous offense has taken place. In that sense, one could at least as a starting point argue that the sentencing policy applies also for cross-border offenders. Which then would be a bit different from the Belgium system, where they in some situations excluded the relevance of a foreign judgment, which is of course also interesting. But then of course to answer the question or to even know where to start, we then have to look at the Swedish national system for sentencing. I would say generally that the Swedish sentencing system is based on we can call them either requirements or principles of proportionality and equality. And this of course means that the penalty should be proportionate to the seriousness of the offense, and of course then that equally serious offenses should be punished equally hard. This also of course then entails that more serious offenses should be punished more severely than less serious offenses. And the general opinion, as expressed also in the preparatory works and the rulings of the Supreme Court, is then that the Swedish sentencing system is strongly influenced by these two requirements, which I think you can also see very clearly from the case law. Now, we could also argue that the requirements of proportionality and equality can be based on also purely the Swedish Penal Code, the legislation, and also in the concept of penal value, which is straffvärde in Swedish. A distinction is usually made between an abstract penal value and a concrete penal value, both being a kind of a quantification of the seriousness of an offense. And the seriousness of the offense relates, let's say, to the blameworthiness and censurability, and is also clearly kept apart from like special and general prevention rationales. I've chosen to describe the Swedish sentencing system with these 5 steps. And as a starting point, I already mentioned the penal value straffvärde. I think I would start there and say that at first that is assessed, and this is mainly done based on sections 29, 1 to 3 of the Swedish Penal Code. And this is, of course, done within the penalty scale applicable for the offense. And let's say in the disassessment, the damage caused by the offense and guilt of the person are decisive factors in determining the penal value. Now, the second step in this, let's say, Swedish sentencing system is then that if such factors are at hand, reductions due to equity reasons and the youth of offenders are made. This is based on sections mainly 29.5 and 29.7 in the Swedish Penal Code. This is maybe also called the first step in addressing what I have called the so-called penal assessment value, which is straffmätningsvärde, and this distinction is quite important in the Swedish system. Now, the third step would then be what I call the choice of sanction. Now, first of all, of course, if the penal value of the offense is only at the level of fines, a fine will be imposed. And this is, of course, based on section 25.1 in the Swedish Penal Code. This is maybe not the most interesting case for our study or our research. But then the other possibility is that if the penal value is of the level of imprisonment, there is, first of all, a presumption against imprisonment in the Swedish sentencing system. This is based on section 34 in the Penal Code. And this means that, as a starting point, a judge should always avoid imprisonment. Let's put it as simply as that. Then therein, of course, the section, there are listed some reasons that can rebut this presumption against imprisonment. And these are a high penal value, a prior record, and what we call the character of the offense. These reasons should then be weighed against the existing equity reasons, if there are such reasons. And when it then comes to the first part, which is the high penal value, I think interesting is that in the Swedish system, a high penal value is considered if an imprisonment or if it is more than 1 year of imprisonment. Then it is considered a high value, which I think is not maybe the same in all systems, if we put it that way. When it then comes to prior record, which is then what we are discussing here, I've chosen to use this translation because it's in the legislation, but we talk about the same thing, where a person has previously been convicted of an offense, återfall in Swedish. When it then comes to prior offense, this normally requires that reoffending happens in the same type of offense, for example, in property offenses, and also within a certain time. This is considered to be within 3 or 4 years. So if the reoffending happened, or if the first offense happened before that, it is in principle not considered reoffending in this sense. And also the number of previous convictions needed for rebutting the presumption against imprisonment also, of course, then depends on the penal value of the offense at stake. Meaning that if the penal value of the offense that the person is being sentenced for comes close to 1 year, you will, of course, need fewer priors than if the penal value is lower, you will need several priors. Then, interesting, there is then nothing, let's say, that forbids reading the term prior record in the section 34 in the Swedish Penal Code, as also including foreign prior records. And this is then what is chosen by the Swedish legislator, that this is how this is taken into account. There's also then includes cross-border records in the term prior record. I should also mention, because I briefly mentioned the character of the offense as one possibility to rebut let's say, the presumption against imprisonment, because I just want to say briefly, it's quite difficult to define what it is, and you can't really find it anywhere in the legislation, but some offenses are considered of that kind of character, art in Swedish, that they presuppose that imprisonment is imposed. And an example of that would be drunk driving or perjury. Now, the fourth step in the Swedish sentencing system is that then if the presumption against imprisonment is not rebutted, a non-custodial sanction should be imposed. This is based on Chapter 30 of the Swedish Penal Code. But if the presumption against imprisonment is rebutted based on the three things that I just mentioned, one should make yet an attempt to avoid imprisonment by invoking so-called special reasons for non-custodial sentence. If these are not applicable, imprisonment will in fact be imposed, and this is all then still based on Section 34 in the Swedish Penal Code. Now, as a fifth and let's say final step, we can also see that if appropriate, a prior record may influence the length of the prison sentence. This is based on Section 29.4 of the Swedish Penal Code. We can see that in principle at least, a prior record can influence, let's say, also the length of the sentence, in addition then to influencing the form of sentence in the choice of sanction. And again, then the way we read the provision and how the Swedish legislature considered implementation, there is again nothing stipulating that this only applies for national prior records. This applies then again also for cross-border prior records. And however, interestingly, let's say, because prior record could both be taken into account at the choice of sanction in what I call the third step, and in the fifth step, which is the final one, it is clear from the Swedish legislation that a prior record shall primarily affect the choice of sanction, which is the number 3 on my list. And this last part, fifth part, only takes the prior offense into account if this has not been fully possible earlier when choosing the sanction. Now, when would this happen? An example is when there are other let's say, aspects that rebut the presumption against imprisonment, and then let's say that the prior record isn't fully used in the choice of sanction situation. For example, then, if the character of the offense, in addition to prior record, then affect the choice of situation or the choice of sanction, for example, the situation of perjury that I mentioned. If there is also then a prior record, this would, in fact, could be taken into account also in relation to the length of the sentence, because it hasn't been fully used in the choice of sanction. But, however, if, let's say, the prior record has been fully used at the level or when we choose the sanction, you cannot use it again to influence the length of the sentence because it's revidism, and then it's not considered a suitable approach. As you already may have kind of guessed, it should also be noted, I would say, on the Swedish legislation concerning sentencing, it's in general quite detailed and quite structured, and I have obviously not described all the details here, but I think sufficient to say is that there are a lot of details, and also that the provisions regulating the matter in the penal code is not always very easy to access. There is not always a very coherent logic, let's put it that way. And, but the detailed and structured nature of sentencing rules is done to achieve both their predictability as well as transparency. And we talked a bit yesterday about depending on like when or how old the sentencing rules are, if it affects how they are structured. Now these are based mainly when there was a big sentencing, let's say, reform in 1888, 89, that would be where the kind of main ideas are based on, and of course with some later amendments. There are nevertheless, let's say, so many different issues influencing the sentencing process in the Swedish system, meaning also that I wanted to present something like this, but I chose not to, because there are simply too many variables and which have an effect, let's say, already on the national sentencing process. And this is without even adding the cross-border element. I would also still, let's say, point out one, maybe not special issue, but another issue that should be noted in relation to the Swedish system of sentencing, that even though the rules and the provisions are fairly detailed, there is still a lot of room for interpretation relating to the rules applicable. And then, of course, the trava preparatoire are especially important in this respect. These are also generally of importance when it comes to the Swedish legal system. In addition, also, then case law is, of course, of importance, and especially here, there is not Usually you always look at the Supreme Court for legal precedents. There are no such when it comes to cross-border previous convictions, but also rulings from both courts of appeals and district courts are important sources in this respect, and I will briefly mention some of them when I come to that part. Now, when it comes to multi-offenders, we've already discussed this, when the penal value of the offenses in general, or the joint offenses, I shouldn't say joint offenses because that gives, when the penal value of these all offenses are measured, usually then a joint sentence is imposed, quite similarly, I would say, as the Belgian system, the same principles apply. And this is then, in most, I would say, normal cases, done by a specific calculation model, which is called aspirationsprincipen in Swedish. This means generally that the penal value of the offenses decrease the more offenses you have committed. You get a rabatt, in a sense. And this is, of course, then the case unless special grounds state that this should not be done, and in such special cases, different sanctions may be imposed in parallel. Now, I've just made an assumption. This is based on the Boräkäs model. There are other similar ones as well in Sweden. Then, of course, may see that the most serious offense is the one that you get, let's say, the whole penal value, which is the one you start with, and then you kind of decrease the, like the more serious you start with, and then you decrease. Yes. And we can also say, of course, this is not done exactly schematically like this every time. It also, of course, depends on the maximum punishment of the relevant offenses, as Nele was also talking about. Now, in section 26.2 of the Swedish Penal Code, it lays down some further rules in relation to a joint sentence for several offenses. Now, this cannot, as a main rule, exceed the sum of the punishments provided for all offenses, or it cannot be longer as 18 years. There were some further restrictions based on the penalty scales applicable. I will not go into all the details here, but I just want to mention them as well. And of course, one cannot talk about the Swedish sentencing system and not mention SOU 2012-34. This is a, let's say, an official report of 2012. It was presented with a proposal that would, I would say, quite largely amend the rules on sentencing in the Swedish system. As an example, conditional imprisonment would be introduced. There is no such thing as suspended sentence at the moment in the Swedish system. Villkorlig dom is not suspended sentence, as I would say in the usual meaning. However, the proposal has not yet resulted in any general government bill to the parliament, and obviously I cannot predict the future, but I can say that it is unclear whether this will happen in the near future, but this should also be noticed. If I remember correctly, there is no mention of the cross-border element in relation to that specifically in this, because the Swedish legislature considered that it's not necessary. Then, what about proportionality and equality, which is, of course, the main question and what we are asking here. The situation, then, for offenders having committed offenses before, either a multi-offender committing several offenses or a repeat offender committing offenses prior to this sentencing, taking prior records into account in a cross-border situation, then follows the normal Swedish procedure, or at least should. One could then argue, at least as a starting point, the Swedish system is then respecting both proportionality and equality, also when it comes to cross-border situations, as there is no specific approach to this stating the otherwise. The same rules apply. And the idea, of course, theoretical idea is, of course, very good, that the situation should be the same regardless of where the previous conviction is handed down. But it is not, of course, a given solution that foreign prior records are always taken into account. First of all, I would say information about a prior cross-border conviction should, of course, come to the Swedish court's knowledge and also be of relevance for the sentencing. Now, of course, the Swedish courts are, in principle, obliged to obtain information on prior records, national and cross-border, when relevant in the case. In practice, of course, then both, I would say, prosecutors or the police is the authority that is in contact with ECRIS, which is the European Criminal Record Information System. I was expecting that you would talk about it, but you didn't mention it. At least then the judges, most in the district courts, do not always have automatic access to ECRIS in the same way as they have to national records, but they then have to go through the prosecutor or the police, which is not problematic as a general rule. And also, as I earlier said, I haven't at least found any precedents from the Swedish Supreme Court on taking foreign judgments into account in this respect. There is also, of course, no implementation legislation, as I said. However, if we look at the case law from lower courts, we can see that the cross-border convictions are, in fact, taken into account. Didn't find that many cases when I searched quite specifically, but I found at least 21 cases of appellate courts mentioning prior records in relation to sentencing, in relation to ECRIS, so it's foreign ones, otherwise I would obviously find more, and 39 cases of district courts mentioning prior records, and especially ECRIS also in this respect. Now, most of these judgments, I would say, address the issue of ECRIS and taken prior records into account in these cross-border situations, just as in national cases. I would say that the way they're taken into account is, let's say, similar as the national ones. So in the case where they discuss prior records, they also look, if there's an international or European context, they look at a prior record if there's a cross-border element, and there is, let's say, it is applied just as the national prior record, I would say, at least from my reading of the judgments. Therefore, I would also argue that the application of prior records in cross-border situations is not all that uncommon, and many consider this to be done as part of the normal sentencing cases, when, of course, there's a cross-border element present. I would also say that here the distinction that has been made earlier here by Nele is of relevance. And I especially then was thinking about what you also said earlier, the difference of taking previous offenses into account in sentencing. Then, of course, for repeat offenders, taking previous convictions into account means usually a disadvantage for the defendant. Here, the taking into account has the effect of revidism, and meaning that in cases where the prior cross-border record is taken into account, just as a national prior one, a defendant would be or could be in a more privileged situation would there not be information of this cross-border element. So this is, of course, one aspect. The other aspect is, of course, then that when prior records are of relevance is of relevance for multi-offenders, when taking them previous convictions into account is an advantage for the defendant when they get a kind of a discount when having committed several offenses. At least from the Swedish system, as explained above, usually in normal cases, a joint sentence is imposed, and this is then done by this special calculation model. Of course, the point is then that foreign judgment should be taken into account in the same way, which I think theoretically is a good idea. I'm not sure if that practically would work based on quite many, jurisdiction, nebis in idem, quite other issues, so I'm not sure if that would actually work in the same sense. But that, of course, which is then for, let's say, for the advantage of the defendant, of course, this should then both work in both ways, and not only in a sort of, only in the disadvantage for the defendant. To conclude, I would say, generally speaking, that the Swedish system is, as I promised earlier on, quite detailed and not always very easy to grasp. And I would say also it is a little difficult to state that there is a specific policy for taking into account cross-border prior records in the Swedish sentencing system, because it is at least not very well enumerated. There is, as I told, implementing legislation as such. There is no precedent from the Supreme Court. However, we can see from the case law of the lower courts that these are in fact applied just as national ones. And we could also, of course, then argue from the aspect that as the Swedish legislature has taken both the requirements of equality and proportionality into account when outlining the national system for sentencing, and because the legislature then considers that there is no hindrance as such to just apply the framework decision and then read that into the national legislation. Of course, there is as such not, or it doesn't make it a very easy task for me to say whether it is followed or not. One would, of course, need to look at even more case law that is applicable. And the question I would say still then remains, is equal and proportional punishment of mere national and cross-border offenders only illusory? Theoretically, I think there should be no difference, as also the Swedish legislator has chosen to have their approach on it. However, I think from the point of view of respecting the fundamental rights of a defendant, I would say that more research is perhaps needed before we can find a definitive answer on the Swedish, let's say, sentencing policy from this regard. Thank you for your attention.
Thank you to both Nele and Annika for for providing us with some insights on the Belgian and Swedish system and comparing the approach that is being developed for repeat offenders as opposed to multi-offenders. I think it's striking that there are some differences but also some similarities between the legal system, and they both have a distinct approach in either or not taking account of prior convictions or either or not considering the possibility of having a cross-border element in those cases. And I think all of us are very keen on answering any of your questions or maybe engaging in a little discussion as to what extent we should bother with ensuring proportionate sentences for multi-offenders. Should we just add it up? That would solve maybe a lot of problems. Or should we try and establish some similarity and some equal treatments between the ones that do and don't have any cross-border elements? So we're open to questions. If some of you would like to share some comments, then that will be very welcome. I don't know if you have questions for each other. It could be.
Well, immediately, no.
We had the opportunity to have a discussion on this over dinner last night. So, all right, if you don't have any questions, then we thank you a lot for your attention, and we will conclude this session. And I think that afterwards, don't know by heart, but I think after a short break, we will come back to this room for the final session of the conference. Thank you.